Hello, everybody, and welcome to IICLE and our Facebook television. Today, I'm with two of my incredibly good friends and partners to IICLE for many years in almost everything we do with the workers' compensation world, Cohn and Richard Aleksey. These two men are experts in workers' compensation in Illinois, and, gentlemen, the reason we're here today is we want to give our audience a couple of little tidbits that they can take home about what's going to happen with the new workers' compensation situation in Illinois.
A lot of people would like to know that.
Well, what's interesting is the fact that there was approximately 31 changes to the statute, and many of them impact some basic rules and processes that have been in place at least since I've been around 1975, and there's going to be a huge sea change in areas like medical payments, medical benefits, choice of doctor, causality, and so on.
You know, Rich, it hasn't been since 1975 that there's been this much excitement and to-do about the changes in the Workers' Compensation Act. We now have a whole new ballgame, I think.
Well, one of the bigger changes, of course, is the application of the AMA standards, the 6th edition, to be included as a factor in determining impairment and disability. You know, before, even if an examining doctor wanted to posit an opinion as to the extent of the disability, we would exclude that from consideration because that would invade the province of the fact finder, the arbitrator or the commissioner.
Yeah, I would say that during my entire practice, employers were trying to change that, and representatives were trying to stay the course and stay away from standards.
Well,
it really dehumanizes the injured party.
Well, exactly. If you take a look at the change just with carpal tunnel, a very, very difficult situation. Some people have no after effects once they have a surgical intervention or some conservative treatment. Others have some significant changes in their physiological ability to do things. But the bottom line is the legislature saw fit to set caps, if you would, on the benefits that can be paid between 15% and 30%. And you can't pass 15% unless there's compelling evidence to show that it should be greater than the 15%. What that evidence is going to be remains to be seen.
And the whole idea of something called utilization review is upon the act now.
Again, utilization review, as you know, has been around for a while, used by health carriers to determine the efficacy of certain treatments and, of course, the length and duration of those treatments. Here in Illinois, utilization review first came into prominence in February of 2006, and it was simply a matter of opinion developed by some stranger to the equation by reviewing medical records as to whether a prescription, let's say, for therapy should be 18 visits or 12 visits or whatever. Now utilization review has been given some more teeth, and in some aspects it's going to be a second and third bite at the apple, questioning the doctor who's treating the injured person, his ability to direct care.
So the employers are going to really take advantage of this or need to know about it?
Well, I think from the employer standpoint, they're saying, look, we need to have some idea of what our risk is, what our exposure is, how much this is going to cost us for a particular injury. And not knowing that always leads to concerns not only in that area of our business, but across the board. And we're seeing it on a economy-wide basis now, this unknown factor, as they call it.
And procedurally, there's certainly a lot of things to talk about, too. Just the whole notion of wiping clean the slate of all the arbitrators.
Well, that's to me is I still can't reconcile in my own mind why that draconian approach had to be used. Since these are individuals, it seems to me they could have been evaluated on an individual basis and then recommendations could be made. However, what the legislature saw fit was, let's get rid of them all, then they can reapply and we'll re-vet them. Some of these people have been veterans and are very, very savvy in the way they run their rooms and the way they adjudicate cases. Now, my hope is that the better ones will, in fact, be retained. And, you know, again, I can't point to any specific examples or think of any offhand of an arbitrator that shouldn't be around. But again, that remains to be seen. Sort
of like throwing the baby out with the bathwater.
Yeah, you're cleaning house. Where's institutional memory? Again, let's remember any adjudicative process is valuable as long as the people participating in the process have some experience, some knowledge, some grounding in what the objective is. If you're talking about a newbie and he's going to be confronted with an issue of somebody's surgical intervention or whether it's appropriate to give any credence to URAC or utilization review, that's going to create some problems.
Well, there's no doubt that we've just talked about the tip of the iceberg. A lot, Patrick, that needs to be aired out.
We're talking about these 31 changes that are coming in. I mean, I know just as before we even started this, we were having a dialogue about the gray areas of the law. We need to have a dialogue about this amongst lawyers. I know your faculty was here today, and I'm sure that people have different opinions about how some of these things are going to actually apply one way or the other.
Yes, as I said, I think it's grayer now than it's been in my lifetime. We'll do our best.
I know you will. Actually, what both Lou and Rich are talking about is they are going to be giving a course for IICLE in July, at the end of July, I believe on the 29th of July.
That's correct.
And it's going to deal with these new issues. And then further, in September, we're going to push another course along and get into even more detail about how these changes are going to apply to your practice. By the way, if you're at all interested in friending us on Facebook, I know that John has got some things that might be willing to get you some discounts for coming to the course. But main thing we really want to do here on all of our social pages is give the lawyer some content and give them some information and not make it a selling point. Gentlemen, I really appreciate your time.
Thank you, Patrick.
Sure.
Wonderful talking with you.